Welcome back, everybody. Today we're going to talk again about the freedom of the press. In particular, a case known as Times versus Sullivan in 1964. When we were last discussing the press, we discussed the case of John Peter Zenger back well before the Constitution was even written. What the case of John Peter Zenger did was it began the process of determining that in libel cases and in cases of where people tried to censor the press, that truth was a defense against libel. Not in every single case. Sometimes there was still some censorship, but generally the principle was that if it was true, the press couldn't be sued or generally couldn't be stopped from printing something. That left open the question of what happens if the press prints something that actually isn't true, if it makes a mistake or intentionally prints something that isn't true. And that came to the fore in the case of Times v. Sullivan, which happened around the time that the Reverend Dr. Martin Luther King was leading protest movements in Montgomery, Alabama. And he kept getting arrested, and so did some of the protesters. It was a time not unlike our own. And a group of supporters around the country took out a full-page ad supporting Martin Luther King in the New York Times. And the ad talked about the students that were engaged in nonviolent demonstrations. It said it was a positive right to live in human dignity. And it accused the Montgomery, Alabama officials in their of unprecedented wave of terror by those who would deny and negate the U.S. Constitution and the Bill of Rights. It was some of the statements in that advertising, however, were inaccurate. Not major inaccuracies, but just things that the advertisement, the text of the advertisement, got wrong. For example, it said that the protesters were singing "My Country, 'Tis of Thee." In fact, they were singing the national anthem. And a little bit more substantively, it got wrong the number of times that Martin Luther King had been arrested. As I said, it was signed by famous people of the time. There were dozens of signers of the ad, actors like Harry Belafonte and Marlon Brando, people of all backgrounds and races. And that raised a little bit of a question, which is very relevant today, which is, does it matter that it was an ad? In other words, somebody else posted it. They bought the right to take that page out in the New York Times. It's like posting something on Facebook, you might say. Should the New York Times be responsible for something that other people had said in an ad? Well, that was pretty clear. If you publish something that's libelous, if you publish something that's wrong, whether or not it's an ad or it's in one of your own news articles, you're held to the same high standard. Let's pause and think for a moment. Does that apply to Facebook today? No, it doesn't. And we'll get to that in a future lecture. But we should be thinking about, should the type of liability that the New York Times and other publishers felt, where they had to make sure that other people's postings, other people's ads were met their standards, whether that should be true of Facebook and Twitter today. The lower courts convicted the New York Times, said that they had made the mistakes, that they couldn't say that truth was a defense because some of what they said was mistaken. Then it went to the Supreme Court, and in a unanimous decision, the Supreme Court says that even if something is not true, that the press should not necessarily be held liable for publishing it or be able to be sued for libel for publishing it. And the reason, Justice William Brennan wrote in the opinion, was that debate on public issues should be uninhibited, robust, and wide open, and that mistakes were part of the price a democratic society must pay for freedom. And he came up with a standard, pretty famous standard now, called the standard of actual malice. And it says that you can be held guilty of libel, and you can be held accountable if you publish something that's false, but only if you do it with knowledge that it was false and or with reckless disregard of whether it was false or not. And he applied this not to everybody, but only to statements made about public officials. And eventually it gets expanded a bit to public figures. In other words, he says, if you're a government official, if you're a public official, and eventually the court said, or even just a major public figure, then there's a standard called the actual malice standard. And even if somebody publishes something about you that's untrue, you can only sue them for libel if they had knowledge that it was false or they had reckless disregard of whether it was false or not. In other words, it allowed the press to make mistakes. It allowed the press to print things that they thought were true, but turned out to be false. And because of that, it allows that robust debate where occasionally you're going to make a mistake. Justice Hugo Black went even further than the majority opinion. He said there should be an unconditional right to say whatever one pleases about public affairs. He said, I believe this to be the minimum guarantee of the First Amendment. And Arthur Goldberg, another justice, also went further. And he said the right to speak one's mind about public officials needs breathing space to survive. The right should not depend on probing whether or not what the motivations were. In other words, probing whether there was actual malice or not. Those were concurring opinions. The ruling opinion, the one that comes down to us and is now part of the law, is actually that standard of actual malice, which means the press gets to make mistakes, but they only get to make mistakes if they were being reckless in disregarding whether something was true or false, or they did it on purpose, knowingly lied, knowing something was false. As I said, Times v. Sullivan applies to public officials and public figures. Ever since then, there's been quite a bit of debate and a whole lot of court cases about whether somebody is or is not a public figure and should be held to that higher standard. An interesting case comes along about whether or not somebody who is just a private citizen is not a public figure, whether or not the standard of actual malice applies, or whether or not the press can be held accountable more easily for printing something that's false about a private figure. And the case involved Elmer Gertz, a very prominent, powerful trial lawyer. And we've talked about the case of Nathan Leopold, the anarchist who killed a kid. He represented Nathan Leopold. He represented the novelist Henry Miller, who was accused of pornography. He represented Jack Ruby, who had been accused of killing, or did kill, Lee Harvey Oswald, the assassin of John Kennedy. And he took on a case of a youth who had been shot by a Chicago police officer. Sound familiar? Yes. That was back in the 70s. We're still facing that today. And an article was written in a far right-wing journal by published by Robert Welch, the head of the John Birch Society, very strong right-wing publication. And it said that Gertz was involved in a communist plot to discredit the Chicago police. And he was involved in the communist attack on the 1968 Democratic Convention. That simply was not true. Gertz was not a communist. He was not involved in any communist plot, either against the police or against the Democratic Convention. And Welch, not only was it untrue, Welch had made no attempt to figure out whether it was true or not. He just asserted it. In other words, he had a reckless disregard for whether it was true or not. And Lewis Powell, for the court, decides that ordinary citizens should be given more protection from libelous statements. That press freedom gave the press an enormous amount of freedom, enormous amount of leeway to attack public figures and even make mistakes when they were criticizing public figures and public officials. But you didn't have that leeway in the free press if you just took somebody who wasn't a public official and said something that was wrong and libelous about them. That, as I said, leads to a lot of discussions about who's a public figure. It also, though, leads to a more important discussion, which is, what is the purpose of a free press? And then in the end, what the case of Times v. Sullivan does is it reminds us that the purpose of a free press is to allow robust discussion, even sometimes mistaken discussion, about public issues, about public officials, about major public debates. But it does not protect the press from invading the privacy of ordinary citizens. The reason we have a First Amendment, the court says, is because of the need for robust public debate about public affairs and public officials. But we don't need recklessness or libel or untruths when it comes to ordinary citizens.